Okay, so now we've talked about why we might want mixed-use development in cities. We need to talk about how we actually create them legally, because the crux of a lawyer's job when you work for a developer is to make sure that you create valid legal titles the developer can sell, because nobody wants to buy land if they don't think they're going to have a secure legal title. And that's what Stratum Subdivision is doing. It's actually creating valid legal titles to separate components of a building. So imagine the planner or the architect has told us that it's a good idea that we have a retail section down here, we have a commercial section here, we have a commercial hotel here, and we have residential apartments up here. Okay, that's the brief we've been given. We've got to create valid legal titles to the building now. How do we do that? How do we create valid Torrens titles? Well, we need to register some kind of plan of subdivision. So we've already learnt about plans of subdivision, we've learnt about deposited plans, and we've learnt about strata plans. For Stratum Subdivision, we are using deposited plans under the Conveyancing Act. So we are going to get a surveyor to draw up a deposited plan. There's a deposited plan on Moodle for a real Stratum subdivision, the toaster down at East Circular Quay, that you can look at your leisure, and you'll see that it is an awful lot more complicated than this little rectangle I'm drawing here. It takes extremely skilled surveyors to do these kinds of subdivisions. But for our purposes, we'll just keep it nice and simple here. Imagine this is our simple deposited plan, and we're just going to call it deposited plan 8976. I've just made up that number. So we're going to register this deposited plan. This is going to become lot 1, this is going to become lot 2, this is lot 3, and this is lot 4. So we have got 4 lots in a deposited plan number 78976, and we've lodged that with LPI. It's been registered. The legal titles to these components of the building have come into existence. Normally we talk about lots in deposited plans. In Stratum Subdivision, we talk about stratum lots. So this will be a stratum lot in a Stratum Subdivision. So lots 1, 2, 3 and 4. So we've actually created 4 separate Torrens titles now for this building. But because we've got a residential component up here, the reality is that Australians, when they're buying apartments, are not prepared to buy really anything other than Torrens freehold title. And so while it would be possible, for example, to have an investor who owns this section of the building and we build it as apartments, and we could subdivide it actually by granting long leases, we could actually do the whole building this way. You could actually, that's a standard way to subdivide commercial buildings, is you have a single owner and you subdivide through leases. But very often in Australia, long-term leases are not attractive to people, and they're certainly not attractive in relation to residential property. So how are we going to provide individual Torrens titles to the apartments that have now been constructed in this top section of the building? Well, we are going to register a strata plan of subdivision. So we are going to further subdivide this section of the building with the registration of the strata plan. And we might actually further subdivide this section of the building with the registration of another strata plan. And that's going to create lots of individual titles to apartments and lots of individual titles to commercial offices. So the owners of these components, and they're probably investor owners or they'll be the developer, can actually sell off individual titles within this stratum parcel, which is what it's called. Sorry, the terminology is a little unfortunate because it gets a bit confusing, but when we register a strata plan of subdivision, a stratum lot becomes a stratum parcel. But don't worry if you find that you're not managing to remember all of that terminology. You can come back and double check it later. Okay, so we've now further subdivided these sections of the building, and because these are strata plans, they're going to have bylaws that regulate this section of the building. This is going to have bylaws as well. Those bylaws of necessity, of course, only regulate those strata plans. So the bylaws only affect the behaviour of people in relation to that section of the building, and these strata bylaws affect people in this section of the building. The strata bylaws cannot have any application to any other section of the building. Okay, now we've created valid titles. So we've got a valid individual title to this. We can sell this off to a hotel operator. We've got a valid title to the retail lot down the bottom. We can sell that off to a property investment trust, for example. And we can sell off our individual strata offices, and we can sell off our individual strata apartments up here. So we've created the legal titles, but we automatically have quite a big problem, because while we have these separate owners and while they actually occupy separate parts of the building, they clearly actually do share a building. And high-rise buildings, more so than most buildings, cost a lot of money to maintain and run. So high-rise buildings down in the basement will have a mechanical room of some description, and it will have a lot of very complex plant and equipment. So it will have chillers, it will have boilers, it'll have heaters, it will have pumps, it'll have fire equipment, it'll have electricity circuits and boards, and they run the entire building. There'll also no doubt in this building be, let me see where I can fit a lift shaft in, but I will imagine that's a lift shaft there. So we've got a lift shaft in this building. That needs to be, there might be more than one lift, of course, that's going to need to be maintained by the owners of the building. So we need to work out a way that we can impose obligations on these multiple owners to pay for the maintenance of the building, and we need some kind of equitable division of the costs of maintaining that building, and probably some kind of rules, minimal rules, about how the building and shared spaces are going to be used, because there will be shared spaces in this building. Most obviously the car park is going to be a shared space, and the foyers are going to be shared spaces, and the lifts will probably be shared spaces. So we need to actually turn our mind to those things so that we don't end up in dispute when people have different conflicting ideas about how the building should be used or how payments should be made to maintain it. Because this is a freehold subdivision, so Stratum's title is about freehold fees simple. That's what it creates. It creates freehold fees simple. These individual stratum lots are freehold titles, fees simple, and then we further subdivided into more freehold titles. We learnt earlier when we did restrictive covenants that in orthodox property law you may not impose positive obligations on freehold land. You can on leasehold title, but you cannot on freehold title. You might be able to remember the name of the cases, but I'll write them down here just to prompt you. Tolkien Moxay is the leading case, and also Pirrie is the High Court case that's relevant here. So you might want to refresh your memory and look those up, but they are the cases that say in relation to freehold fee simple, you cannot sell a freehold fee simple and impose a positive obligation on it. And the most typical positive obligation is an obligation to pay money. So now we have all of these freehold titles that we've sold to people, but we haven't been able to impose obligations on them to pay for the upkeep of the building, but we know logically they are going to have to pay. Now it is possible that for the developer to actually extract contractual promises from people. So when the developer sold lot 1, and imagine they sold it to A, they could have extracted a contractual promise from A to pay for the upkeep of the building. But what you're probably already thinking now is that contracts are insufficient, because as soon as lot 1 is sold by A to B, this contractual promise is in no way enforceable against B. So contract law is not sufficient. What do we need? We need property rights, okay? Because the point about property rights is that they bind whoever owns the property. We can't do it through orthodox property law, so the Conveyancing Act allows us to do it. So the Conveyancing Act is where you do stratum subdivision. So I'll just write this up here. The actual sections of the Conveyancing Act are mentioned for you in the Moodle material, so you can make reference to them. But that's where you'll find the provisions. And what the Conveyancing Act allows you to do is it allows you to, if you wish, if there is no strata schemes in here, you can register a building management statement. And if there is a strata scheme anywhere in the building, you must register a strata management statement. And all those things are documents drafted by the lawyers that allocate costs for the maintenance and repair of the building. And that's a really big deal. I know it sounds just like, oh, it's just costs, but it's a very, very significant issue in the ownership of any property, but certainly in the ownership of a piece of property that is as complex as a modern high-rise building. So these documents are drafted by lawyers, and what they try try to do is efficiently and fairly allocate the costs for various bits of the building to make sure, for example, that the retail owners are not paying substantial or possibly any costs for the maintenance of the lift because they never use them. They never go to the top of the building. You don't want the residential owners having to pay for commercial garbage removal because they're not using commercial garbage removal, and sooner or later they're going to become very annoyed if they discover that they're paying for it. Everyone needs to pay for fire security in a building, so sprinklers and pumps. Everyone has an equal interest in the building not burning down, so those contributions should be allocated equally. But the BMS or the SMS is the document that allocates these costs. How do we make sure that even when people on-sell their lot, so the commercial hotel lot is sold, it was originally owned by X and now it's been sold to Y, how do we make sure that Y is bound by this obligation in the same way that X was? Well, we make sure that this is registered. Okay, by registering the building management statement or the strata management statement, it becomes a statutory property right. It binds anyone who owns one of these lots and obliges them to pay. We will also have a building management committee, and that is made up of the owners of the strata lot. So obviously it's going to be the owners corporation who's a member here, the individual owner of the hotel, the commercial owners corporation and the retail lot owner. They will all be members of the building management committee and they will manage and run the building in accordance with the building or strata management statement. Now that's a little easier than it actually is in practice because drafting these things well is extremely difficult. It is very, very hard to know how a high-rise building is going to actually operate until it's been up and running for a number of years. And very often these end up with quite serious mistakes in them. And you may find that people like the residential owners eventually feel that they are paying more than their fair share for the maintenance and repair of the building. So there are increasing numbers of cases now that relate to disputes over building or strata management statements, and you'll find a list of them in the Moodle materials. So if you're interested in reading them, you can look at them yourself. Okay, so just finishing off on this presentation, just going to show you some pictures of some real stratum subdivisions so you can see that this really is a increasingly used form of title in Sydney, and if you ever work in development, you're going to need to understand this title. So the first building I'm going to show you, or stratum subdivision that I'm going to show you, is the Renzo Piano building or Aurora Place. It's at the top of Macquarie Street. It was one of the first residential buildings to be built in almost a century on Macquarie Street. Macquarie Street used to have a lot of residential development, then for most of the 20th century it didn't until this building was built. This is a relatively straightforward stratum subdivision. It actually is two high-rise buildings. So there's one high-rise building that contains the residential apartments, and there's another high-rise building that contains commercial offices. So relatively straightforward, and then there's some sort of space they share in the plaza at the front. And the importance of something like that, the legal structure that's been used for the Renzo Piano building, is it really makes sense to get residential owners and commercial owners out of the same scheme. If you put them all in one strata scheme, that can be very difficult for commercial owners when Mrs. Smith in Unit 27B is telling them where they can put their signs or how they're meant to do their commercial garbage disposal. So stratum subdivision allows you to separate different users into separately owned components of a development site. So like I said, Renzo Piano, relatively simple, residential tower, commercial tower. And they really don't have that much to do with each other. Moving down Macquarie Street to the Toaster, which is one of the most iconic buildings in Sydney. This is a very large and very complex stratum subdivision. So from the photograph, you can see that it actually has, its street address is actually multiple buildings. It's number 1, number 3, number 5, number 7, and number 61 Macquarie Street. And it has multiple strata schemes within the stratum subdivision. There are multiple residential schemes, and there are also multiple retail strata schemes. So the shops and the restaurants there are strata lots, and they're separate strata plans within an overarching Stratum subdivision. There's also a very large commercial hotel in 61 Macquarie Street. So it's a very complex development. It's a really important development for Sydney. It makes that area of Circular Quay so much more vibrant than it is. Probably a lot of you are not old enough to remember what that area of Circular Quay used to look like, but it didn't look like it does today. It wasn't a really vibrant and exciting site with lots of restaurants and a cinema and places where people live. So it's a very successful development, and Stratum Subdivision is what allowed it to happen. I'll just finish on this little anecdote that demonstrates, I think, the importance of secure land titles. When that building was built, the residential owners park underneath the building, so they park underneath the toaster. But to actually access their parking, they have to drive through the Opera House car park. And if you've ever driven into the Opera House car park, you drive down Macquarie Street and you go into the Opera House car park, and then you go round and round in circles and you find a park, but the residential owners in the toaster go into the car park there, and then they go to their own parking spot under their own building. But because they're driving over the Opera House car park, I'll let you think for a second, what do you need if you're going to drive over somebody else's land? Permission, contractual permission, is not really good enough. What we want is a property right. And you're probably thinking quite rightly, we need an easement. They need to have an easement to drive over the Opera House car park. The only problem was that the Opera House was built under an Act of Parliament. It didn't actually have a deposited plan. So without a registered deposited plan, it wasn't possible to create a registered easement in favour of the owners of the apartments in the toaster. So the lawyers who were working on the toaster development had to liaise with LPI to create a deposited plan for the Opera House car park, so they could then in turn create a registered easement for the owners of the apartments in the toaster. So it all worked out well for them, but it demonstrates the importance of having secure land titles through registration, and Stratum Subdivision is the vehicle for creating very complex titles in very complex mixed-use developments.